Good evening, everyone. So lovely to see a good many of you this year. This is a regular event we have every year. Normally, it's Duncan and I, and we split it, so I do the common law and Duncan does the statute law. This year, you're getting 3 for the price of 2, which is very good because there's no price at all. You're getting Sarah Walker as well. And so my common law property is itself being split. I'm doing just the common law and she's doing the statute law, and then Duncan will be doing the property law. And you've only got to listen to each of us for 20 minutes, so that should be tolerably okay. So in the usual way, we're going to have a few pictures as we go along. My talk is confined to only about 4 or 5 cases on, as it were, basic common law. And what could be more basic than lease or license? And there was a case that came along called, with the name on this slide, AP Wireless, and another one of these telecoms cases. But don't worry, I'm not going to talk about telecoms law because there's other people who understand it far more than I do. And also it's a bit too abstruse for this sort of interesting talk. Mr. Justice Edwin Johnson, because there's 2 Johnsons now, you probably know, Adam Johnson and Edwin Johnson. He was sitting as the president, is the president of the Upper Tribunal Lands Chamber, and he was dealing on appeal with a case in which he had to decide, as one of the key points, whether the 2 agreements were leases or licenses. And he is a very analytical guy. If anyone had instructed him at the bar, I was against him as an opponent. He was a very thoroughgoing guy. So his judgment in this case is 318 paragraphs long. And he said, the question which arises is whether these agreements take effect as a lease or a license. And at the first tier tribunal stage, the agreements were found to be licenses. And then the freehold owner appealed, contending each was a lease. I mean, very curious. The whole thing about telecoms is sort of back to front and Alice in Wonderland. You wouldn't normally have the landlord saying that it was the lease and the other way around, but in this particular case, that's what they were saying. And the judge decided that both agreements would have been viewed as leases, but in fact, even more curiously, he found that one was, but the other one wasn't, because it wasn't for a fixed term, nor was it a periodic tenancy, and therefore it didn't satisfy that other ingredient of being a lease. Now, the reason that I'm mentioning the case is that the judge identified the general principles that arise, quote, in considering whether an agreement has given rise to a lease or a license. And he then discusses the general principles, and there will in due course be some emailed printout. Well, actually, it's a contradiction in terms. There'll be an emailed something from paragraph 74 to 101. And so I'm just going to go through those principles, which I can happily say you will all already know. So all you need is a sort of reminder if you're doing a note on this to a client or something. You will find all these principles in this case. So there's 8 points, I think there's 8 points, 9 points. Starting point is Street and Mountford, so you know all about that. That's just, exclusive possession at a rent. And he deals with that, and he quotes Lord Templeman's famous passage, which I've not put in the note because I'm sure you know that. And then set point 2 is, although that was a residential case, the principles in Street and Mountford do apply equally to business premises, and the judge helpfully actually says that. There's a sentence, and I've given you all the references for this. The labels, he says, may be indicative but are not determinative. I mean, there used to be a thought that labels didn't matter at all, but there have been some cases where the judges have said, oh, well, this looks more like a license, and therefore, or a statement that it's a license, we can give some effect to. You look at the whole agreement rather than just a few clauses, and they're construed in the same way as you would any other contract. This is all rudimentary stuff. Where documents form part of the same transaction, you can look at them. Obviously, if they aren't part of the same transaction, then you should not do so. The conduct of the parties after the event shouldn't be used to help you in construing the agreement. Again, that's all pretty basic, but it's quite useful because all these little points that you would normally have to search for authority for, they're all there. And then what's exclusive possession? And he deals with the famous adverse possession case, Pye and Graham. And I think that reminds me that I've got, yes, here you are, I've got a pie to remind me of Pye and Graham. And you'll know that that is the 2 elements for exclusive possession are factual possession and intention to possess. Not intention to get title, but just intention to possess. And then the final thing in the notes is that enclosure is the strongest evidence of adverse possession. That is a thing that we probably all know. Right, I'm now moving on to, this is quite a really interesting case, because as I'll tell you at the end, so I might as well tell you now, it's a case involving a lease where in fact there was a forfeiture, and what is more, relief was not granted. And this was another case with quite a long judgment. It's Mrs. Justice Bacon. The case is called Tropical Zoo, as you'll see in the London Borough of Hounslow. It's a funny, I don't think there were any giraffes within the Tropical Zoo. Indeed, the zoo never got to be built. That's part of the story. She had to do three things, she explains in her judgment. She had to construe a covenant in a lease. She had to decide whether the right to forfeit had been waived. And then she had to consider the grant of relief against forfeiture. And so when she dealt with the construction of the lease and its covenants, she covered that in a mere 20 paragraphs. So I've just given you the paragraph numbers to look at. Then in waiver of forfeiture, she actually summarized the principles in 4 passages or 4 paragraphs, which is quite useful. And she reminds us what we already know, that a right of forfeiture will occur when 2 things are satisfied. First, the landlord knows the facts giving rise to the right of forfeiture. And secondly, with that knowledge, the landlord does an unequivocal act which affirms the lease. So those 2 things would amount to waiver. And the question as to whether you've got an unequivocal act of waiver is objective, not subjective. And then then there's a distinction, you probably know, where you've got waiver between payment of rent and other things that you might do, like granting a license to a sign or some kind of license. If it's rent, and the rent accrues due after the date on which the landlord had the knowledge of the breach of covenant, that is a waiver, even if the acceptance of the rent was accidental or incidental, and that's to be contrasted with any other act of waiver. Perhaps I should add in, it's not actually in the case, but because I've been in cases like this, that there's a little doubt in the law as to whether a demand for rent is the same as accepting the rent. The tenor of the authorities is that a demand for rent is akin to receiving rent, but I argued this in the Court of Appeal once, and they decided they didn't have to decide the point because I was going to win anyway. But so I have to flag up a demand as being in a slightly different category. But otherwise, if you were the landlord and you take the rent, even if you wrote back saying, I'm not waiving the breach, nonetheless, you would be, because you've just taken the rent. But otherwise, you ask yourself whether there's an unequivocal act that can only be regarded as consistent with the continued existence of the lease. So you've got some quite useful statements of the law there, and means you don't have to look up any old books. It's all there. And then she considers the law as to regards relief against forfeiture in about 5 paragraphs, which I've given you the references to. And then, as I told you in my little trailer earlier on, she decides that there's been a breach of covenant. She decides the lease was forfeit, and she decides that relief against forfeiture would be refused. So in the tenor of more recent cases like Fryfield and stuff like that, where the movement has been towards willingness to consider the grant of relief, albeit on terms, in this particular case, because the breaches by the tenant were particularly egregious, she has decided that there would be no relief at all. Now, we move on to another case about forfeiture. My sort of analogy for forfeiture is cutting off your head, so that's like cutting off the head of the lease. And there was a case that got to the Court of Appeal on whether a long delay in pursuing forfeiture proceedings might mean that you would no longer succeed in getting your forfeiture. And it's relevant to mention a few of the dates, so you pick up the story. So there was a tenant with a flat in a converted country house under a long lease. And in February 2014, the landlord issued proceedings in the county court alleging breaches of covenant that had commenced in 2007. So 7 years earlier. So 2014, allegations of breach in 2007. And their forfeiture notice was 2013. So breach is 2007, 6 years later, the forfeiture notice, and another year later, you get the proceedings. And then the following year, 2015, the tenant applies to strike out the claim on the ground that the landlord hadn't been entitled to serve the forfeiture notice because there'd been no admission of the breach, nor a finding of the breach. And that you'll probably know is section 1684 of the 2002 Act, one of the many impediments that there are now to taking action against residential tenants. And the district judge didn't grant the strikeout and made an order referring to the FTT various issues about whether there'd been a breach of covenant. And the county court proceedings were stayed pending the FTT giving its ruling. And then some more years went by, and in 2019, the tenant applied to the county court to strike out the claim on the ground that the landlord had failed to refer the issues to the FTT and was in breach of the court's order and guilty of inordinate and inexcusable delay. And the district judge did strike out the claim, but the circuit judge allowed it back in again, and then there was an appeal to the Court of Appeal. And the Court of Appeal said the categories of abuse of process were not closed, and abuse didn't necessarily depend on a failure to comply with the rules or a breach of a court order. And the main question was whether the lapse of time in bringing the claim was an abuse. And I think it was Lord Justice Lewison in that case said, well, I can't find that there's really been an abuse here because there was the earlier decision of the court staying the county court proceedings, and the way in which the order was framed didn't mean that there was a breach. So with a sensed a degree of reluctance in the judgment, nonetheless, it was found that the forfeiture proceedings could still be pursued. So that's a forfeiture case. And then I'm going to come to, right, now I've come to a case or the litigation which I have mentioned before. In fact, I think I've mentioned it on about the last 3 or 4 of the last times I've been doing a talk. And it's what I've called the 89 Holland Park litigation. And if you've followed this, as no doubt you will have avidly followed, it relates to property in, surprisingly, 89 Holland Park. And you had a block of flats, well, not a block of flats, but a house that had been converted into flats, I think 5 flats. And next door, there was a blank piece of land, and some lady architect who had glorious plans for what she wanted to do, devised some plan. It was going to be all glass, partly under the ground and partly over the ground. But there was a restrictive covenant between the person who owned the lady who owned the land that was unbuilt on in favour of the property which was occupied by the flat owners. And there was litigation that went all the way up to the Court of Appeal, all about how you construe the covenants and what you take into account, all of which I've talked about previously, so I'm not going to bore you by talking about it again, but you can look it up. And there's reference to it in some of the judgments. They give you a thumbnail sketch of what happened in the past. But it then became controversial because then you had another array of litigation, because what had happened is initially all the flat owners had leases, and the leases all had provisions for paying money via the service charge. And so the lessees had got together and they had jointly instructed lawyers on behalf of themselves and to oppose the building work next door. And so they were all together. But it was very expensive. I don't know, in this particular case, the lawyers were ridiculously expensive, so it wouldn't have included any of us here, you know, we would. So, ridiculous sums of money were spent, and the Dells, who occupied one of the flats, they had enough. And in the end, they said, we paid hundreds of thousands of pounds, and so we don't want to pay any more money. And they made it crystal clear they weren't any more consenting to any obligation to pay. That meant that their liability to contribute to the costs would only arise if it could be brought within the words of their lease. So you had a typical, or a little bit less than typical case, where you had to look at the words of the lease, and wherever you've got issues over service charges, whether they're mediocre, small scale stuff, or in this case rather big scale stuff, nonetheless you had to argue over that. I seem to recall, in fact there were 5 flats, because in the judgment of Lady Justice Falk, Because what happens is, at the first instance, the FTT decide that the legal costs have got to be paid. I think they were something like £400,000 or £450,000. It was a huge sum of money. And that wasn't all the legal costs. That was only the last bit that they weren't agreeing to pay. And the FTT found that there was liability, but the upper tribunal found there wasn't. And the Court of Appeal upheld the upper tribunal and decided the Dells didn't have liability. And so I've set out in the notes what the basic background was, which I have already told you about. Oh, and yeah, the disputed costs were £430,000. I actually wrote these notes. I've been in court for many weeks, and so I wrote these notes a long time ago. So anyway, it's quite interesting to read my own notes. So the principles are set out by Lady Justice Falk in paragraph 18 of her judgment, and she goes to a little-known case called Arnold and Britton, and the judgment of Lord Newburgh in that case. And you'll remember Lord Newburgh's got a few paragraphs of very generic significance, but I don't downplay it because they're very important. And then he says, I think there's 7 points that he then says he wants to emphasize. So Arnold and Britton is a case that you need to turn to. And he then says, after 6 general, so he's got the very general points, then he's got 6 important points. And then he says, the 7th point is specific to service charges. And and it was this. Reference was made in argument to service charge clauses being construed restrictively. I am unconvinced by the notion that service charge clauses are to be subject to any special rule of interpretation. So you've got Lord Newburgh saying service charges, they're part of a contract, you construe them like any old contract. A landlord may have simpler remedies than a tenant to enforce service charge provisions. That's not relevant to the issue of how one interprets the contractual machinery for assessing the tenant contribution. And then there was a reference to how you approach service charges. And so he said, he then refers to what Lord Justice Ricks said in the McHale case and says, what the judge was saying quite correctly was that the court should not bring within the general words of a service charge clause anything which doesn't clearly belong there. And if you've ever had to wrestle on these cases and advise on the construction of service charge provisions, and particularly the sweeper clause, hence I've just remembered why I had a broom, that's the sweeper clause, you look at the words and then you're trying to find a word that catches the particular expenditure. And this case, the Dell, of course, the expenditure wasn't the normal sort of expenditure that fits in within the building. It was actually expenditure on legal costs involving a neighbour. So that's not typical, and there wasn't specific wording catching that. And Lady Justice Falk put her finger on a point that I've had to wrestle with in the past. She says there's an element of tension between the principle that service charge clauses are not subject to any special rule of interpretation, and Lord Newburgh's approval of Lord Justice Ricks's statement, which is all about you interpret the I missed out the words. Yes, they're not subject to any special rule of interpretation, but he'd indicated that you don't bring things within a service charge clause unless they clearly belong there. And so there is a tension, but she then says it's more apparent than real, and that leases are typically long-term obligations with potential for significant future liabilities. So that's quite an important point to remember as opposed to the normal sort of contract. And so what they were basically saying in that case is that parties wouldn't enter into a transaction that committed themselves to obligations that are neither expressly spelt out nor clearly fall within the words. And so there weren't words that clearly. But the arguments about service charges, I mean, there's books written about service charges and lots of cases, and even if you read a book from a few years ago, you probably find it was out of date. And they looked at various cases, including a case called Ken Square, which I was in and talked about here a couple of years ago. But that's the end, I think, of 89 Holland Park, because as I tell you in my notes, a few months ago, the Supreme Court refused permission to appeal. So perhaps next year, when you turn up to hear next year's talk, you'll be relieved to know that I won't be talking about 89 Holland Park management. And that, I think, brings me to the end, exactly on time, of my 20 minutes. So I'm going to now give way to Sarah.
Thank you, Mark. So I'm going to deal with landlord and tenant law arising under statute rather than the common law. And I'm going to work through the statutes in chronological order. I'm mindful of my 20-minute allotted time, and so it's going to be a bit of a whistle-stop tour, but as Mark did say, there will be a handout afterwards which goes into rather more detail. It also means don't stress about taking notes because you will get it all afterwards. So the first piece of statute I'm going to deal with is the Building Safety Act 2022, so the most recent, and I think it's fair to say there's been a quite significant amount of litigation under the new Act. Again, I would say it's probably fair to say that the overall thrust of that litigation is that where the FTT can justify making, for example, a remediation contribution order, they will find a way to do it, but there is some variation in that. Just as a little bit of very high-level background, the BSA 2022 was enacted following Grenfell. You may actually notice that there's a Grenfell inquiry meeting happening today here as well. And it came into force on the 28th of June 2022. It contains provisions intended to secure the safety of people in and or about buildings and to improve the standard of buildings overall. It's divided into 6 parts. Part 1 is introductory. Part 2 creates the post of a building safety regulator and describes its functions. Part 3 amends the Building Act 1984 to confer powers and duties on the regulator. Part 4 is about higher risk buildings in England and creates the status of accountable person and the duties that go with it. And it's this part that I think most of the litigation has focused on. And then part 5 is about the leaseholder protections, and part 6 contains general provisions. So with that little introduction, we'll go to the first case, Triathlon Homes. The current or most recent judgment in this is the upper tribunal. I understand it's going to the Court of Appeal next year, so very much watch this space. It was the first major case in which the FTT had to consider applications for a remediation contribution order under section 124 of the BSA. And it arose in relation to what historically was the Olympic Village. The application itself concerned the cost of rectifying fire safety defects in 5 tower blocks in the Olympic Village, and was made by the long leaseholder of all of the social and affordable housing in the blocks. That was Triathlon. The total cost of the work was said to exceed £24.5 million, and Triathlon sought an RCO of some £18 million from the developer, which I'm going to call R1, but also its parent company. And this is a really interesting facet of the judgment, and I understand from Mark has resulted in further litigation. In fact, Mark's involved in another matter where they're going for companies and parent companies. I think 95 respondents was suggested. So it was agreed by all the parties that jurisdictional requirements to qualify for an RCO had been met. So we're not talking about that. What the case establishes is, first of all, in terms of the scope of section 124, number one, that the FTT has jurisdiction to make an RCO in respect of costs that have been incurred prior to the BSA 2022 coming into force. So it's not just everything, it's not purely prospective, it's also retrospective, and there's no temporal limitation on those costs. The second big point is that an RCO can be made in respect of costs incurred in preventing risks from materialising or in reducing the severity of building safety incidents. So things like a waking watch or the installation of temporary fire alarms and other precautionary measures. Again, the point being, it's not just about actually sort of building work to remedy defects. It's all sorts of measures that might keep people better safe if the building isn't safe in the first place. The other key part of the judgment is the very helpful guidance on the just and equitable test. Indeed, this is the case giving guidance on that, although watch this space in terms of the Court of Appeal. I'm going to highlight a few points to be drawn out. Number one, the ability to apply for an RCO is a new and independent remedy, and it's not fault-based. So we're not looking at if anyone's done anything wrong, it's self-standing. Here, the upper tribunal said it was created by Parliament as an alternative to other fault-based claims, which a party may be entitled to in relation to those same defects. Number two, an interested person who is entitled to bring a claim, in this instance triathlon, they're entitled to seek an RCO under the BSA, and it's irrelevant what their motivation for that is. Again, we're not looking behind people's reasoning or anything like that. If you have status, you can do it. Number three, an important factor in the policy which underpins section 124 is that the primary responsibility for the cost of remediation should fall on the original developer, and that others who have a liability to contribute may pass on the cost they incur to the developer. Number four, in circumstances where the developer, here I refer to it as R1, would be unable to comply with an RCO in any significant sum without financial support from a wealthy parent company, it would be just and equitable to make an order against both parties. Number five, it was no answer that the remedial works had been or were being funded by the Building Safety Fund, given that the taxpayer does not appear in the list of people in section 1244 against whom an RCO order can be made. The tribunal said it's difficult to see how it could ever be just and equitable for a party falling within the terms of section 1243 and well able to fund the relevant remediation works should be able to claim that the work should instead be funded by the public purse. Number six, the ability or inability of a respondent to pass on liability to some other party who may be responsible under the general law is not a matter which much weight should be given. However, the tribunal has ample jurisdiction under the provisions as a condition of making a remediation order to impose such terms as are required to make the contribution just and equitable, including, for example, requiring repayment by the recipient of the contribution in the event of it successfully pursuing claims against third parties. And finally, parties can't contract out of section 124, and there is nothing unfair in an applicant taking advantage of the ability to apply for an RCO independently of any contractual provisions which may exist between the parties. So we move on to the second case, another case under the BSA. This related to an estate on Canary Riverside. Here, the question on appeal was whether a manager appointed by the FTT under Section 24 of the Landlord and Tenant Act 1987 was an accountable person within the meaning of Section 72 of the Building Safety Act. It arose in a preliminary issue before the FTT made in the context of an application under Section 24 of the LTA 1987 as to whether the current FTT appointed manager's appointment should be renewed and on what terms. So before they dealt with the renewal, they were going to first deal with sort of almost what his status was. Here, Martin Roger KC confirmed that the FTT's first instance decision that the manager was not an accountable person under Section 72 was correct. And his discussion of the issue begins at paragraph 85. When he deals with his judgment, he acknowledges that, in a way, it's not entirely clear-cut, and he was almost choosing the lesser of two evils. He also accepts that the finding that he made means that where you have an FTT appointed manager where their appointment predates the BSA 2022, there is likely to be a period when the manager has responsibilities which may overlap with an accountable person under the BSA. Nevertheless, his view was that that didn't make them an accountable person for the purposes of the provisions of the BSA 2022. So then we move on to Lowe and Governors of Sutton Hospital. This is a case under the Housing Act 2004, and it relates to tenancy deposits. I think this may be the first case, dealing with tenant, oh no, superstrike would have gone up too. But this is one of the very few cases that has gone on appeal in relation to deposits, because often the sums in issue are so small that it's not worth litigating this far. The point in this case was that it actually was a claim for some £120,000. And in fact, I think it is the largest known claim under the tenancy deposit legislation. The first instance decision was made by His Honour Judge Luber KC, a preeminent judge in the particularly Central London County Court, and the appeal was heard by the other Mr. Justice Johnson, Mr. Justice Adam Johnson. The judgment provides some helpful clarity on a number of points. The first is limitation. The second is the effect of Section 215B of the Housing Act 2004, and the third is the application of established common law principles relating to the interpretation of statutory notices. So slightly dipping my toes into Mark's area, but just for this case. On limitation, the court held that the claim for repayment of a deposit was caught by Section 9 of the Limitation Act, and so the applicable limitation period was 6 years. On Section 215B, the court held that where a deposit was paid in respect of a tenancy, which was not a short hold tenancy at the time of payment, but later became one by operation of law, Section 215B would still apply, and so you would have the protection of that provision. And finally, in relation to the interpretation of statutory notices, there's 2 points to note. The first is that a certificate of information containing an obvious error should be construed in the same way as any other statutory notice. So if the reasonable recipient of that notice would understand the correct information to have been given, that would satisfy the requirements of the legislation. And secondly, the lack of a signature upon a certificate of prescribed information was not fatal to its validity. In this case, the certificate had been provided under a covering letter, which was signed by the agent of the landlord. The information was therefore given in a form substantially to the same effect as required under the 2007 order, and so it satisfied the requirements. What's happened there? Sorry. For some reason, there's a slide missing, so we'll keep going. My next case is Asset Hold Limited and Evelyn Road RTM Company Limited. It's 2024 EWCA Civ 187. And this was a case dealing with the Common Hold and Leasehold Reform Act 2002. Here, the Court of Appeal was considering the question of how the right to manage provisions of the CLRA 2002 applied in the context of terraced houses, hence my lovely picture of terraced houses, which had been converted into flats. So in this particular instance, what you had is you had 2 terraced houses that had each individually been further subdivided into maisonettes. So you had 4 units, but 2 houses. And so what the Court of Appeal was considering was what size of unit applied for the RTM provisions. The Court of Appeal upheld the upper tribunal determination and held that there was nothing in the wording of the Common Law and Leasehold Reform Act that required an RTM company to limit its claim to the smallest possible configuration of premises. So it didn't just have to be a maisonette, it could be a bigger amount, a bigger building, shall we say. Provided that the whole of the building or self-contained part of the building in question is in common freehold ownership, then the leaseholders had the freedom to elect to make a claim to require the RTM of either 1, a self-contained part of the building, regardless of whether it contained within it a smaller self-contained part, or 2, the whole of a self-contained building. What that actually meant was that the whole of the 4 maisonettes could be an RTM altogether, which meant that the service charges and things could be dealt with in a much more efficient manner, rather than having to have 2 separate RTM companies for the 2 separate terraced houses. Next, we have Bank Holdings Limited and Lupo, which is a case decided in relation to the Housing Act 1988. This can be dealt with very quickly. It's a short point, but I think a helpful one in the instance that you have to deal with the point, as it were. It clarifies that where an individual has succeeded to an assured tenancy, the periods of the tenancy remain the same, irrespective of the date of death of the previous tenant to whom the new one has succeeded from. Then we have St. Francis. Obviously, this litigation has been going on some time, and I'm sure you'll have seen other iterations of the rather long-running saga. This one, we're looking at the Landlord and Tenant Act 1987. And in this case, Mr. Justice Richards considered the validity of default notices served under the LTA 1987 and the exercise of the court's discretion under that provision, under Section 19. When a freeholder failed to offer qualifying tenants a right to first refusal prior to granting roof space leases. There are 2 points to note here. First, the court held that a default notice need not take any particular form. The requirement is simply for the document to do what Section 19.2 requires, and to do that, it did not need to specify the method by which the purchasers were to comply with their statutory duty. In this case, it did not matter that the default notice attached to TR1, which requested a transfer for £1. In fact, the document clearly conveyed that the claimant was requiring the defendants to make good their default in complying with the duty imposed. And secondly, the notice was not invalidated by the fact that the consideration, as found by the court to be payable, was different from what the qualifying tenants had actually specified in the default notice. The judgment is also worth reading for its very helpful summary on the court's approach to exercising its discretion under Section 19, but I'm not going to deal with that in this talk. And finally, I come to Graham Bradley and Abacus Land. This is a case dealing with the Landlord and Tenant Act 1985, and this is also, at the moment, due to go to the Court of Appeal next year. Permission has been granted. This is an important decision in the context of apportionment and reasonableness of service charges. Here, the appellants were leasehold owners of flats in a development owned by the respondent landlord, and under the terms of each lease, the leaseholders were required to pay a service charge comprising of sums designated as residential buildings, parking or otherwise, apportioned according to the landlord's discretion. Now, of course, you may be aware that there's a difference between whether or not, or when you have to exercise that discretion, if there's no express contractual provision for how that discretion is to be exercised, generally the situation is that it has to be done rationally. But where you have an express contractual provision that it has to be reasonable, then the reasonableness test applies instead. Now, in 2013, the landlord's predecessor in title granted a lease to a third party, the gym, hence the picture of the gym, and the gym lease was for a term of 999 years without a repairing covenant. Significantly, unlike the residential leases, the gym lease did not require the gym tenant to contribute to the landlord's maintenance costs, and the respondent's predecessor and later the respondent therefore apportioned all the gym costs solely to the residential leaseholders under the terms of the lease. From 2013 to 2020, the residential leaseholders' service charges included the entirety of the gym costs. However, that was not without demur from the residential leaseholders, as those charges were partially offset by a contribution from the landlord reflecting rent received from the gym tenant. But that situation escalated from after 2020, when the respondent landlord, due to a dispute with the gym tenant, that involved refurbishment of the gym and rent holidays and things like that, indicated its intention to charge the full gym maintenance and refurbishment costs to the residential leaseholders. The leaseholders applied to the FTT for a determination, and the application, as I said, raised questions about the interpretation of the lease terms regarding the allocation and apportionment of such costs the fairness and reasonableness of charging residents for gym costs given the changed circumstances regarding access, and the implications of the generous terms of the lease. Now, this is an interesting case exploring the distinctions, as I said, between acting reasonably and acting rationally in the context of the apportionment of these costs. On appeal to the upper tribunal, Mrs. Justice Elizabeth Cook held that because there was an express provision that the discretion had to be exercised reasonably, and that had not been done so, the costs were not recoverable at this time, and instead the landlord would have to go and re-exercise its discretion, because at the moment the FTT doesn't have jurisdiction to deal with that. But this is going to the Court of Appeal, and watch this space in terms of that rationality, reasonableness juncture, and also potentially the FTT's jurisdiction in terms of exercising the discretion. And with that, I will turn over to Duncan.
Thank you very much, Sarah. My name's Duncan Kynoch. If I could ask you, after that illuminating whistle-stop tour through landlord and tenant, to turn your minds to real property, because I'm going to talk about recent developments in real property. I'm going to start with the law of nuisance, mainly because there's been 4 Supreme Court cases in the last 18 months dealing with nuisance. And I would invite you not to switch off if you're not instructed by Shell or Water Utilities. These cases are of universal application, and you may have anyone darken your door with a question about the law of nuisance. The most recent case is the Manchester Ship Canal case, which involved the defendant United Utilities Water Limited discharging vast amounts of foul sewage into the Manchester Ship Canal, which obviously upset the canal owners who owned the bed and the sides of the canal. Believe it or not, the Water Utilities Industry Act 1991 does permit discharge of foul sewage into common waterways, canals, and so on. But the question in this case was whether that statute excluded a private claim in nuisance. And the Supreme Court held on the particular statutory interpretation of the Water Act 1991 did not exclude the law of private nuisance. So a victory for those who are concerned about escapes or foul sewage being discharged into private waterways or public waterways. So again, a victory for the private law of nuisance. That's the first of the 4 cases. The second case is the well-known case now. It's probably the most widely reported case in 2023, the Tate Gallery case, which many of you will be familiar with, and I mentioned last year. That was a case about overlooking, and although the Supreme Court in that case emphasised that it was really about the Tate's exceptional use of its land. If you'll recall, the Tate Gallery in London had a viewing platform from which thousands of people every year bought tickets and had lovely views across London. Unfortunately, some of those people were taking pictures of people's living rooms and intrusions on their privacy in some neighbouring flats, and those flat owners sued, and the Supreme Court reiterated that a nuisance must be a substantial interference with the enjoyment of neighbouring property. It had to be give and take between neighbours, but they could only be expected to tolerate the common and ordinary use of the land. And what the Tate Gallery were doing in this case was not common and ordinary, allowing thousands of people onto a viewing platform was not ordinary use of the land, which is ultimately why the Tate Gallery lost. You may recall that the Tate Gallery argued that the neighbouring flat owners should take mitigating effects such as installing net curtains, blinds and so on. And the Supreme Court said, well, that's a bit like blaming the victim of a burglary for not having proper locks, which is a graphic way of putting it. And the Supreme Court said the issue was not that the flats were particularly sensitive to being overlooked, but the Tate's use of the land was extraordinary. So that's the second case, the Tate Gallery case, which I'm sure by now you're all familiar with. The third case is Jalla and Shell International Trading. That was an oil case, a Nigerian oil case, where Shell had some of you may recall the Macondo Gulf of Mexico spillage. It was a similar spillage to that, except it was 6 hours. It was an isolated leak of oil, which in the usual way spread. It hit Nigerian shores, and Mr. Jalla, who owned some land in Nigeria, complained that it was a nuisance to his land. The difficulty for Mr. Jalla was that he hadn't brought the claim within the 6-year limitation period. So he was driven to argue that despite the oil spillage being a one-off, as it were, isolated incident, Mr. Jalla alleged that there was a continuing nuisance on the basis that the oil was still on his land in order to get around the limitation problem he had. And the Supreme Court didn't accept Mr. Jalla's arguments, and it held that the nuisance, in order to be actionable, had to be a repeated activity of an ongoing state of affairs, and didn't cover an isolated escape outside the limitation period. So Mr. Jalla's claim failed. It is actually interesting, these cases, these nuisance cases deal with causation, loss, and extending the boundary of the law of nuisance. So they are worth reading. The last of the 4 nuisance cases in the Supreme Court in the last 18 months is Davis and Bridgend Borough Council, which is a Japanese knotweed case, which, as many of you will know, Japanese knotweed is an invasive species which has rhizomes which are very difficult to get rid of and can render properties sometimes unmortgageable. Certainly, the mere mention of Japanese knotweeds usually gets surveyors excited, if not lawyers. Mr. Mark Davis, in that case, bought his house in 2004. There had been, from neighbouring council land, Japanese knotweed escaping onto his property. But in 2004, no one really knew about Japanese knotweed. It wasn't until 2013 that RICS sent out an information paper saying you really ought to do something about Japanese knotweed to owners of land. So the difficulty Mr. Davis had in that case was that the damage by the invasion of the knotweed took place historically. So the Supreme Court said that, you'll remember from your lecture, your law lecture days, that the but-for case in tortious claims must apply. So the question was, but for the actual damage, had the council been guilty of not removing the knotweed? And the answer was no, because it had been historic. The damage had taken place historically. So again, Mr. Davis lost his case. I move on to, I'm going to talk about easements, and then I'm going to talk about boundary disputes, and finally a contract of sale case. For property practitioners, easements, rights of way, rights of light, parking, it's going to darken your door at some point, so you need to know what the main areas of dispute as far as the law of easements are concerned. You're probably going to come across a prescriptive claim at some point, so you need to know about Section 2 of the 1832 Prescription Act, which essentially says, codified the old common law in requiring a claimant to prove 20 years of long user for a prescriptive easement, usually a right of way, but it can be anything, drainage, right of light. But the use has to be, I know we're discouraged from using Latin, but nec vi, nec clam, nec precario, so openly, without force and without permission. Usually the defence is there's some sort of permissive element to a prescriptive easement claim. So if you're facing a prescriptive claim, look for permissive use in the first instance, because that's often the defence. But so prescriptive easements is one area that you need to look at. Lost modern grant, people have heard of it, but very few people actually know how it applies in practice. It's often run as an alternative case, and you shouldn't exclude it. It assumes a fictional grant, a historic fictional grant based on long user. So once you establish 20 years of user as of right, so nec vi, nec clam, nec precario, then lost modern grant can apply. And why would you use lost modern grant as opposed to a prescriptive claim under Section 2 of the 1832 Prescription Act? The answer is, under Section 2, claims, so the statutory claims for prescription, you've generally got to prove 20 years prior to the claim, without obstruction, without interruption, without permission. But there's no such restriction with lost modern grant. You can prove 20 years at any time. So it's not right up into the claim. So that's normally why lost modern grant is advanced in the alternative. The other area which you need to know about in law of easements, which comes up in practice, is the concept of excessive user. So there's usually a historic express right, which in some way, usually by a developer, is being used excessively, usually to build houses or units, and some historic use is being expanded or enlarged. So one more area that you need to have regard to is, again, if you're on the defendant's side, is the question of signage. Because if you can obstruct a prescriptive easement by a carefully worded sign to make that use not as of right, but contentious. So a sign, if properly worded, can make the prescriptive use contentious, which is sufficient to stop time running for your 20, or I should say 40 years. You can have 40 years user under the Prescription Act, Section 2, and people, you might ask, well, why 40 years over 20 years? The benefit of 40 years is that under Section 2 of the 1832 Act, a defence of permissive use for 40 years has to be in writing. So 20 years oral permission is a defence, but it's no defence if it's 40 years. So you have an absolute and indefeasible prescriptive claim if you can establish 40 years. But I just mentioned that in passing. I now get on to the cases, Merlin and Balaam and another, which concerned a right. It's about excessive user, this case, and there was a historic right of way. 6 dwellings were historically used. A developer came along, wanted to put up 27 dwellings with another 10 to come, and the farmer said excessive user. However, the defence failed because there was no proper evidence, no particularised evidence that the actual level of interference was substantial, and so the defendants failed. So the moral of the story is, if you're going to run excessive user, probably take a note every time that there's some sort of interference, and be very careful about advancing your evidence. You need extensive and comprehensive evidence of actual interference in order to establish excessive user. I mentioned the signage cases. One of the cases I've mentioned in the notes, there's 14 pages of my notes, so you can look at the detail as you see fit. They're very fact specific, the signage cases. And I mean, to give an example, if a claimant asserts a prescriptive right of way, for example, and a defendant says, no, look, I've got a sign up which says no parking, that wouldn't work. No parking wouldn't work, because if someone was asserting a prescriptive right of way, which fell short of, so just going from A to B, well, that's not parking. So a sign saying no parking wouldn't work. So they're very fact specific, these cases. Sagir and Core, the sign was no public right of way. That didn't work on the facts of that case, because it wasn't the public who was using the particular way, it was members of a residential housing development. And so that sign failed to establish that there was contested user of the right of way. But on the other hand, in the other case I mentioned in the notes, Nicholson and Hale, the words in that case on the sign were, this staircase and forecourt is private property, no public right of way. And that was in the context of a residential property. The sign was by some stairs going down into a basement. And the upper tribunal held that it was difficult to see what message it conveyed other than that the garden was private land and not to be used by others, and that the use was contentious. So the sign worked in that case. I move on to the law of boundaries, my favourite topic, highly acrimonious, contentious boundary. That's what Mark tells me anyways.
Middle name.
There have been a number of cases dealing with questions about boundaries. Charlton and Forrest, I mention this because of the use of expert evidence in this case, of aerial photographs, Google Maps, Google Earth photographs, was decisive in this case, in a case where, to quote Mr. Justice Zaccaroli, the relevant conveyances. So normally, obviously, in a boundary dispute, you look at the conveyances primarily to see where the boundary is. You don't necessarily look at the HM Land Registry title plans because of the general boundaries rule, which is that the title plans actually don't tell you where the boundaries are. They'll tell you who owns the land, but they won't tell you they won't tell you where the boundaries are. And often people are confused by that, because they will look at the title plan and say, oh, look, well, it's quite clear from the land registry title plan that this is the boundary, because that's where the line is. No, this case, and indeed all the other cases, have said, well, no, the general boundaries rule applies. So don't be misled by the title plan. And in this case, the reason I mentioned it is there were no conveyances available. They were lost in the mist of time, to quote the judge. and it was all about a line of trees that had been cut down by the defendants. The judge had to determine where the boundary was. The experts agreed that the boundary was down a certain line, what they called the red line. And the judge said, thank you very much, but the question of a boundary is a matter for the judge. It's not a matter for the experts. And he said, I'm going to reject, or not reject, I'm not going to accept your evidence. I'll decide where the boundary is. Thank you very much. And people can miss that point sometimes. It is a matter for the court to, as a matter of fact, applying the law as to where the boundary is, not what the experts say. Anyway, having said that, he was greatly assisted by the aerial photographs produced, and that's the reason. That's the headline, really, is why I've mentioned this case, in where there is ambiguity, such as the conveyances are not available, and it's a rural type case. Do look at the historic photographs, which you can find, or the experts will be able to find on Google Earth. I move on to Taylor and Jones. Now, you probably, when you got to law school, you probably didn't think that you'd be studying the Party Wall Act 1996. It will darken your door at some point. Basements are not as popular as they used to be, but there's still enough work going on that people are engaging the Act. As you all know, there's a notice procedure under the Party Wall Act 1996. So if you're going to start work, you'll either, and it's within the requisite distance of the party wall, usually 3 meters or 6 meters, you need to serve a notice either under Section 2 or Section 6 of the Party Wall Act 1996, and engage the proper, and normally surveyors will be instructed, or one surveyor for both parties. And if there's a dispute, it usually goes to a third surveyor who produces an award which settles any difference. And normally it works quite well. There have been some cases where people start doing work without any notice at all. And those of you who came last year heard me talk about a case where no notices were served at all. And the court held in that instance that the common law applies. So where the notices have been served properly, you usually end up with an award. And what happened in the cases which come before the courts is usually there's some damage done by the building owner's works to the adjoining owner's property, and there's an argument about how much the damage or compensation should be under Section 7 of the 1996 Act. And the important point in this case is that when Mr. Taylor, who was the building owner, extended his garden, did his works, the telltale cracks appeared in the adjoining owner's property. The third-party surveyor said, well, they're going to cost this. In his award, his third-party award, served it on Mr. Taylor. It then transpired that the adjoining owner had been the subject of pre-existing damage. So it already had cracks, even prior to Mr. Taylor's works. And the third-party surveyor included that remedial damage compensation under Section 7 in his award. So perhaps understandably, Mr. Taylor appealed, and in short, the Court of Appeal said, when I read these cases and you think, well, that's obvious, the Court of Appeal said that a building owner is only liable to compensate for damage caused by their works. So Mr. Taylor was not liable to pay for the pre-existing damage or the pre-existing problems with the adjoining owner's land. And I say that's, but went all the way to the Court of Appeal to establish that. But I know some people in this room are very familiar with the 1996 Act, but you should consider it because you'll have to apply it if you're a property practitioner. The other boundary case I mentioned is Clapham and Naga, which is hot off the press from the Court of Appeal, I think on the 11th of November, so it's last week. It's a difficult read, this case, because with the greatest respect to the lower courts, they confused the law. Now, those who have dealt with adverse possession cases will know, or have been in practice for long enough, will know that the old law used to be that if you had been in adverse possession for 12 years, so I say the old law prior to the Land Registration Act 2002, which has severely restricted the circumstances in which adverse possession can now lie. But under the old law, particularly as regards unregistered title, if you had, as an adverse possessor, been in adverse possession for 12 years, you therefore got possessory title. And even if later on a person post the Land Registration Act 2002 registered their title or applied to register their title, it would not include the land already excluded from the title by that possessory claim for 12 years. So if you ever get a case where your client tells you, oh, well, I've been in adverse possession of this land since 1965. You know, it's been in the family. My predecessors have been there since year dot. And at that time it was unregistered. The 12 years old law still applies. And that was the point in this Clapham and Naga case, which the judges at first instance got wrong, because they found that the land registration regime did apply, even though the land was unregistered prior to 2003, and 12 years adverse possession had been acquired prior to 2003. And the Court of Appeal said, no, if you register the land as at first registration, if there's already an existing claim by the adverse possessor, and they've established their claim over 12 years on first registration, that disputed land is therefore not part of that title. It's already been extinguished. So the possessory title is taken out, and in effect, that was the result in the Clapham and Naga case, which I always thought that was the law, but at first instance, it wasn't held to be that, but the Court of Appeal corrected it. So adverse possession is, historic adverse possession is still relevant if you can prove it back to the 20th century. You've got to get 12 years prior to 23rd of October 2003. So, which takes you back to October 1991. So if you've got 12 years prior to October 1991, you've still got a good claim for adverse possession. The regime under the 2002 Act has become far more restrictive. So post the 2002 Act, the main area of adverse possession are those cases where a party is in possession of land for 10 years. It's not 12 years, it's 10 years. And they're in possession because they have a mistaken belief about the position of the boundary. So it often happens where, for example, someone's boundary fence is in the wrong place, and their neighbour is an occupation of land right next to the boundary. And the neighbour mistakenly thinks, because the fence is in the wrong place, that that's part of their garden. That's now the main area of adverse possession, mistaken boundary cases. And I move on finally away from boundaries to my last case, which is the only case on contracts for sale. This was an auction case. Property was in an auction. Purchaser comes along, makes an offer prior to the auction, persuades the auctioneers to allow the property to be removed from the auction. It was sold prior to the auction, as is often the case. Anyone that's turned up at an auction knows that all the good properties go in advance, and you're left with the troubled properties in the auction itself. But you know, you're all property lawyers, so I'm sure you'll see all the problems with all those properties with horns on them. But this was a case where the property was sold prior to the auction, but the contract didn't comply with Section 2 of the Law of Property Miscellaneous Provisions Act 1989, in that, as you know, all the terms agreed have to be in the one document. Well, that didn't happen in this case. And so the purchaser said, he later discovered the problems with the property and wanted to pull out. He said, aha, well, the contract doesn't comply with Section 2.1 of the 89 Act, so I want my deposit back. The contract is void. And he was successful in that argument. The judge found where the contract is void by reason of failure to comply with Section 2, purchaser is entitled to his deposit back on a restitutionary claim, and on the basis that there's been a total failure of consideration. Thank you for listening. That concludes my cases. I'll hand over to Mark because I'm sure, has got some invitations for you coming. Thank you.
I've got two final comments to make. Thank you very much, Duncan. Thank you very much, Sarah. Firstly, the postscript, as Sarah's mentioned about triathlon homes, that we will no doubt, as a Chambers, be doing some kind of seminar on the Building Safety Act. It's the sort of thing it's quite bulky, and so you may have tried to run away from it, but I suggest you run towards it because it's the source of a lot of litigation. In the triathlon case, you had the people who'd done the remedial work were recovering the money from the developer. The developer didn't have much money as a company, but it had a very wealthy parent. So the two people who were found to be liable were the developer and the developer's parent. And that's because you can get a remedial contribution order from both the developer and those associated with the developer. And if you read the associated type provisions, there's a sort of company association in terms of shareholding, or they have a common director. So there was a director, the same of both R1 and R2. So it was pretty easy to show that there should be liability because there has to be a common director showing association, and it's got to be just and equitable. And the court said in triathlon it's just and equitable. Now, the case I finished, which is why I wrote my notes several weeks ago, I was doing a case for 2 weeks, involves a block of an office block converted into 73 flats, I think. And the work to remedy the problems has cost about 15 million. And so the developer is being sued. And then there were a couple of directors of the developer, and they're also directors of another 95 companies. So 95 respondents have been joined. I acted for about 65 of them, and various other lawyers and barristers acted for the others. And so the argument about what is just and equitable has ranged uphill and down dale, and we will find out what the answer is after Christmas. But I invite you to come along to a seminar, which we haven't even arranged yet, because you'll find that there'll be some benefit in times of Building Safety Act. And the second is a rather more general comment. I am genuinely grateful on behalf of Selborne that you've all come along. We seem to grow in terms of the numbers every year, which is very good news. And we've also got a much more impressive venue than we used to have. So it's very good you're here. And so while you're here, you might as well come and enjoy our hospitality because we've got some drink and food outside. Thank you very much indeed.